Oh, okay, nice. Good afternoon. This is the House Judiciary Committee on January 10th. We're going to be today getting some background information from some witnesses regarding the criminal and civil justice system, an overview. Just really quick before we get into that, I'm wearing my mask today, and some folks are wearing their mask, and that's fine. I was a little spooked this weekend with all the various articles talking about the latest variant that is going around, and just being extra cautious myself. Folks, it's an individual decision in here. There's not any mandate at this point because Washington County isn't at that level of transmission that we require masks. In any event, I do ask people that if they aren't feeling well and if they are going to be here and not feeling well, if they could, out of respect for folks, wear a mask. So anyway, we're going to start with Professor Bobby Sands is going to give us an overview at a higher level, and he'll explain the exercise that we're going to undertake. Why don't you join us if you could? Thank you very much, and if you could just identify yourself for the record.
I will, and I'll just.
And it's fine to have your message.
That's me. Hi all, Robert Sand, go by Bobby, I use he, him pronouns. I am a professor at what is now known as Vermont Law and Graduate School, founding director of the school's Center for Justice Reform, and advisor to the National Center on Restorative Justice. I am the outgoing high bailiff for Windsor County, a job that was too taxing for me. And for almost 16 years, I was the Windsor County State's Attorney.
Bobby, is that outgoing as far as personality goes, as far as?
I have become even more introverted, but it was, yes. Did not seek re-election. The campaign was too grueling last time. Yes. And so the views I'm going to express are mine and not my employer's. I was asked to talk about theories of punishment. Why we punish. Why do we deliberately inflict pain or other adverse consequences brought to bear on a person who's committed a crime by the state? And so to help frame why we punish, I wanted to do a little exercise, and each of you should have a handout. It's, I think, 4 paragraphs. It's intense. It is fictional, but it is still intense. And I would love to just shut up for a minute, 2 minutes, and let you go through it, and then we're going to talk about it.
And for those watching at home, this is on, I'm pretty sure, our website.
It is.
People can take a look at it there, the scenario.
maybe the longest period of silence in this room.
People who come down and look, they're probably wondering,
It was kind of nice.
look, yeah, one doesn't know how to run a.
No.
Not saying anything.
I can't get in trouble if I don't say anything. So a couple of things that I'd like to emphasize. One is the penalty that's set forth here in the final paragraph. That's not Vermont law. So for purposes of this exercise, I want you to assume there's no presumptive sentence, there's no mandatory sentence, there's simply a cap of life. Second thing that I want you to assume is that Mr. Jones enters what we sometimes call a blind plea. And what that means is there's no negotiated resolution with the prosecution, with the state. There's no plea agreement. He simply is saying to the judge, through counsel, I'm prepared to admit my guilt and receive any punishment that the court thinks is fair and just, from no period of incarceration all the way through to life imprisonment. All right, any questions about that aspect of it? I'm going to ask you to each take one of these handcrafted note cards and pass them down, please. Oh,
Can you repeat that again, what he pled?
thank you. So he pled guilty to the charge of second-degree murder, the intentional killing of another, not in immediate self-defense or in defense of others. All right, and he's entered a blind plea. Now, by the power vested in me by absolutely nobody, I now appoint each of you the presiding sentencing judge for Mr. Jones. And so what you need to decide is how much time, if any, he should serve. And then we're not talking about release or probation or parole, what happens after this initial period of time, but simply how much time as an initial matter he should serve. A couple more things. Let's use 6-month increments so we have some consistency. This is designed to be anonymous. So I'd like you, like when you're taking, I don't know, whatever, SATs or something, cover your answer and turn it over. And for the whole time I'm talking, no one needs to know what you said would be appropriate. And your clerk can participate as well, if she's so inclined. Any questions?
I have a question.
Yes, Your Honor.
Do you care about the methodology for which we come up with that number?
That's what we're going to talk about afterwards.
Oh, okay.
This is lead-in.
Okay.
Should we assume that he's being held before the trial?
Sure, let's say he's been held for a year, if that helps, which technically doesn't meet the definition of punishment because it's not by virtue of a conviction, but we treat it that way quite often with credit for that time. All right, so a number between 0 and life, 99 years, that you as the judge would impose as an initial matter on Mr. Jones. When you're done, don't fold. If you would just pass, oh, it doesn't really matter. Just pass them down would be great. Thank you. Wait, I feel like a magician here.
I hope. Let's unfold it.
Feel like I'm back in grade school.
It's great.
Don't fold.
Oh, it doesn't matter. I don't want to,
Again, maybe he'll pass us.
distinctive fold.
I doubt it.
This is a tough group.
All right. You ready? Holy moly. Okay. This person needed more information. 5 years. 5 to 10 years. 5 years. 40 months. 25. 10
These years are months now.
years. 10. 0. 10. 0. So 0 to 25. Any thoughts from anyone about just right off the bat, that range or that span? Forget it.
I was the outlier at 25. And that's probably why I don't have discipline problems. But that being said, I was thinking in terms of, the rest of the process as far as the possibility of parole.
Mm-hmm.
And that's based upon behavior.
Mm-hmm.
And, he did do the crime, did admit to the crime. And, a reasonable amount of time, for him to get his act together actively, for me personally, was that range, knowing full well that he might be eligible for, parole at 5, 10.
Maybe, yeah. Okay. One of the things that this exercise always shows me is that everybody has a different sense of what is justice. And you'll oftentimes hear prosecutors in particular say, my job is to pursue justice, as if that is some objective measure. And it really is. There's a huge subjective overlay. And any prosecutor who says my personal perspective doesn't enter into the process is either deluding whoever they're talking to or deluding themselves, because there is a lot of subjectivity, particularly in a sentencing scheme that's as wide open as this one is, and most statutes in Vermont are that wide open. The other thing, I'm curious about your thoughts. What was it like having to make a decision, admittedly very quickly?
The only thing I knew to do is I ran to Title 13 and looked up 2301, but I didn't get to the punishment part fast enough. So I guessed I was going to go with the minimum.
The minimum.
Because he took the deal. Or
So
he
you,
offered to, he knew what he was doing.
Okay.
And I was okay with that. And then they could work with that later.
interesting. Okay. I have to say, I was a prosecutor for 22 years. Having to be the one who makes that final decision, I think, is really challenging. It's easy to be an advocate. It's really hard to be the one who makes the ultimate decision. Okay, theories of punishment. So regardless of what you indicated, what are some reasons to punish Mr. Jones harshly? What are some reasons that would warrant or justify substantial incarceration?
Secondary deterrence, not keeping us down from murdering someone else, because that doesn't seem likely, but the societal message that do we want everybody to be a vigilante and
Okay. Other thoughts on why he should be punished? Again, whether you agree with it or not, punished harshly.
In case he someday has offspring that follow down the same path like he did his father.
Right. I've heard people say in response to your observation, well, high-strung young man, we might think it's just a familial situation, but maybe that is how he reacts. And so what's the certainty that it's not going to happen again with some other relationship? Any other rationale for substantial punishment?
I guess, and I did not advocate for substantial punishment.
That's-
I guess I would say, zooming way out and just considering what he did and the need within a society. So I guess deterrence, but also like to make a statement about, to strongly state, like, you can't just choose to end another person's life.
Okay, good. We'll come back to that. Okay, so let's flip it. What are some reasons not to incarcerate for a substantial period of time? To take a different approach? Am I allowed to call? I'm sorry.
This is very professorial.
Yeah, I know.
Usually I would call them people, but please, you go ahead and call them folks.
I borrowed this jacket. I wish that there had been
Right, yeah.
patches
We're
here.
in law school right now, so you're.
I never wear a tie.
So there's not, the evidence is not great that long prison sentences make any difference. And
Okay.
it's costly to the taxpayer. And in fact,
Okay. Other reasons to not punish harshly.
This young man needs help. And I would worry greatly that he would not get the help he needs over the duration of a long prison sentence
Okay. Within a facility.
within a facility.
I guess my thinking about that is if I would look at the systemic need for change in the system whereby we could affect that behavior, with supports. And then we're investing in rehabilitation and consequence at the same time. And it has more possibilities for restoration.
It's a perennial struggle about how many services exist within a correctional facility. Because on the one hand, we say, of course, we want people to have options for education and training, rehabilitation. The flip side is the more options there are, arguably, the more attractive it is to sentence people to prison. And so I personally, I really wrestle with that. So here's what I want you to think about. Representative Arsenault offered that, I've forgotten your exact words, but there had to be consequences for this behavior. And the retributive theory of punishment looks back to the time of the offense and says blameworthy conduct is deserving of punishment. That's the retributive theory of punishment. It's this concept of just deserts, which until quite recently I thought was spelled with two S's. It isn't. It's what is deserved. So a pure retributivist doesn't look to the future at all, but looks to the time of the conduct and says that behavior deserves punishment, regardless of whether punishment changes behavior, costs too much money, etc. The flip side is the utilitarian perspective. And a utilitarian will say the only reason to punish is to serve social values, social utility, typically enhanced public safety. So the utilitarians look to the future. We're going to impose a consequence now because it's going to create a better outcome later. So what are the components of utilitarianism? And you've touched on many of them. First, we have specific deterrence. The idea that punishing Mr. Jones is going to deter him from re-engaging in criminal behavior. In addition to specific deterrence, there's this message sending, and you hear a lot of this in court. General deterrence. The idea that punishing Mr. Jones is going to send a message to the community that you can't engage in this behavior. Deterrence theory works if you're aware of what the punishment was, and deterrence theory works if you are a rational actor. But if you are impulsive or perhaps under the influence, you're maybe not engaging in the kind of cost-benefit analysis that is the backbone of deterrence theory. Utilitarian approach is rehabilitation. We are going to impose consequences because we hope through addressing whatever those rehabilitative needs are, things will be safer in the future. And finally is incapacitation. Now, we might think incapacitation is a retributive notion, but utilitarians believe in it as well, because if someone poses an ongoing risk of harm to others, looking into the future, separating, isolating them, incapacitating them furthers that utilitarian goal of enhancing public safety. So those are the main pillars are retributivism and, easy for you to say, and utilitarianism. Almost no one is purely one or the other. And there's no legal requirement to espouse one theory or the other. One of the things that's interesting, if you go hang out in a criminal court, is a particular judge might sentence one person and the language at that sentencing hearing sounds very much retributive. You did X and X deserves punishment. But for the very next person, the judge might say, you know, if you address some of these issues, we're confident you can be a productive member of society. So there is no one unifying theory that controls. I think the problem also raises the issue about how much latitude does the legislature want within the criminal code. You know, if we each were spread out throughout Vermont and imposing sentence, there was a 25-year range. And if we're talking about a criminal legal system, does that much discrepancy further our goals? Flip side is if the legislature essentially predetermines outcomes, is that justice? And my whole career has been a pendulum swing between crafting responses versus getting more guidance from the legislature about what's appropriate or not appropriate.
So that metaphor, case by case, really comes into play. Because it sounds like, based on the evidence in each particular case, it might tip the scale in one direction or another. Just judging from the examples that you shared.
Who's presiding is going to tip the scales. There's actually some study about whether they're hangry or not. This is true for parole boards. The parole boards after lunch are more lenient than parole boards at like 11:30 when they're impatient. And but I mean, I think for better, though I'm not sure. There's an amazing amount of discretion. So you have individually elected state's attorneys who get to advocate for a position, and then we have individual judges, and our judges rotate. So what side of a county line you're on and who your state's attorney is and who your presiding judge is at any given time has a very substantial bearing on what kind of outcome you received. Which does suggest that I think better data management, maybe a topic for another day, might be useful. So I'm done.
I appreciate this. I haven't heard of it in this theory context, and so this is very helpful. I'm curious, and this might be outside of the box, but I'm curious if you can share the piece that I feel like is missing is that's what the judge, the decider, is. What does the victim want? Where do they land?
Okay.
Which is not a part of it. And then also I feel like it's not looking at what is the public, impact for our community of somebody being labeled a criminal. We're looking at public safety, but then what is that once somebody's labeled a criminal, does that affect our public safety as well? So I'm curious if those fall into either of those theories.
I don't know that they fit into theory. There's certainly, we have statutory requirement that the victim or harm party have voice. And I think that could cut both ways, retributive or utilitarian. I mean, we could think that the mom here would not want her son punished and would say, he's got lots of potential, so we want a utilitarian approach that's not going to lock him up and get him the help that he needs. You could also envision a scenario where the mom says, yeah, my marriage wasn't perfect, but this was horrible. This was my life partner, and I don't want anything to do with my son again. So I don't know that it fits neatly into one. I appreciate someone wrote, how can anyone make a decision off of a little more than a page of information? Which is true. So what other questions do we need and do we want? I have to tell you, though, that it is not unusual for major life decisions to be made by judges based upon a piece of paper. It's a police affidavit. Typically, the case is negotiated. I think it's 90-something cases resolved via plea agreement. So judges every day are making decisions based on pieces of paper.
Okay, hands up.
Okay.
So obviously I'm the one that wrote that there because first of all, a 22-year-old kid is still living at home. He's been brought up with all that abuse that's going on. Nobody got mom out. Nobody got any help for that, right? Mom decided to stay there, and we enabled a father to keep beating the crap out of somebody, right? Doesn't make a lot of sense to me. I don't know how us, and maybe this doesn't really pertain to this, but this is my way of thinking. I don't know how anybody in legislature or anybody making laws or anything are going to protect somebody like that when they won't do anything to protect themselves or a very limited scale to protect themselves. In other words, it never should have gone on 22 years. There's been a lot of us, let me rephrase that. There's been a lot of people that have been brought up in an abusive relationship. They've seen this happen, and they've dealt with it in different ways and have learned in different capabilities. So that is my thing with this whole thing. And a judge that's going and listening to this, sure, he's got maybe a page and a half or whatever of paper, but he's still taking a lot of other considerations. And like when I'm first going over this, I have all these questions going up because maybe I do have some experience with this. And my first thing is why would my mom stay with a guy like that? And then the kid, instead of going down the road he did, and at 22 years old, again, what's he doing there? I would have got out as soon as I could, and I would have looked at it as a learning experience, and I would have become a very good dad instead of a scumbag.
Which way does that cut in terms of consequences now that it has happened?
That's where I would go for more than this page and a quarter, and I'd listen to what had happened, and then I'd make the best decision I possibly could. That's why I answered the way I did.
I will say that I have never been a victim of domestic abuse, but I understand the dynamic for why people stay even in abusive situations. And so sort of my privileged rational mind says, oh, you should get out. The moment of greatest lethality for domestic partners is when they try to leave. So there are a lot of rational.
Very, very, probably one of the biggest decisions that a person can make when they're in that situation, whether it's their mother or whether it's the kids that are involved.
I guess just in response to what Ken's bringing up, just there's other parties that are in some way responsible for the action of a fairly young person. And while he's not a minor anymore, my understanding is brains are still just finally developing at that age. And so I guess that's what I hear when you bring that up is like, there's all these other potentially culpable parts of the system, not just individuals that didn't support that family.
It's probably pretty
like that.
clear that nobody did anything.
One of the things we're not good at anywhere in this country is looking beyond the immediacy of the criminal conduct. So we look at that in isolation. One of the things I like about restorative justice field is it widens the lens to look at other contributing factors. I mean, one could say that every case that comes to court is an opportunity in a positive sense, but we haven't treated it that way. We treat it as something deserving of punishment with very mixed data on the efficacy, particularly of incarceration.
So a follow-up question to Karen was asking about victims, and we provide a lot of victim services in statute as well. And that would seem to suggest that we do want to follow where the victim wants to go, presumably. And the question is, is that really true? Because you mentioned that this mom could have been retributive or restorative.
Right.
And apparently we have set it up in statute that will be a factor that the judges should hear, presumably the prosecutors as well. I mean, any comment on that?
So we have statutory requirement for victim impact statements. So judges shall consider that. That doesn't directly translate into outcome. So yes, I considered, however. Part of the problem, from my perspective, is we are so schooled and steeped in punishment as the response to achieve justice that victims, harm parties, think that justice means they have to ask for incarceration. I think if people better understood options and honestly understood some of how hard it is to go through some of the community-based responses versus the passivity of receiving something from the state. And I'm not suggesting incarceration is easy. It is not. It's brutal, but it's someone passively receiving something from the state. If victims knew the language better, I think their requests would be of a broader nature. So, what does it mean? The court must consider, but that doesn't translate in numerically in terms of outcomes. And, often it's I think your next witness can probably talk to this a little better. I've been out of the room for a while. It's a written statement. And so there's a lot more nuance. There are a lot of contributing factors. And we have a system that, even with backlogs, is incredibly efficient. And I think that is the enemy of justice, that we need to slow down and look at other factors and think more carefully about what consequences should be. And to say one last thing, and I'll get in trouble here, and I don't care. There's a lot of finger pointing that goes to prosecutors and goes to law enforcement, and the criminal legal system is created, inherited, and then maintained by you all. And so you have the chance to figure out, is the system doing what we want it to do? There are many people who say criminal legal system is broken. I think the criminal legal system is doing exactly what it was designed to do: separate and marginalize and stigmatize. And if that's not the system that you want, you all have the ability to to work toward a different system. I've suggested to your chair, he'll probably get mad at me, that it would be an interesting exercise to try to write either individually or collectively a preamble, an introductory section to the Vermont Criminal Code. What do you want these set of laws to do? And it'd be amazing if you could agree on language, but I think it would help create a lens through which you would look at legislation over the course of the biennium. I have one last, trying not to editorialize too much. I'm going to editorialize about one thing. And there was some mention of this earlier. Being charged with a crime is a serious thing. And there is no such thing as a non-serious crime. If it is a criminal offense, you all have decided that it is a serious matter. Famous U.S. Supreme Court case Gideon says that indigent people are entitled to counsel. But Gideon has been limited by subsequent decisions to say only for serious crimes. Under Vermont's public defender statute, if a person is charged with a misdemeanor and the court says on the record that it will only impose a fine, that person is not entitled to a public defender. So we are essentially telling poor people that you're on your own. And the reality is that getting convicted, even of a misdemeanor, can have lifetime consequences, even if it's expungible. So this committee, over 2 biennium, has passed a law that would make any indigent person charged with any crime eligible for public defender services. The other body has not seen fit to take up that issue, though one of the champions here, a former colleague of yours who's now in your parallel committee in the other body, has introduced a bill over there, S7, to say that every indigent person charged with a crime is entitled to an attorney. There is a really compelling book called Punishment Without Crime that I recommend to all of you by Alexandra Natapoff, Natapoff. And it is about the perils of the misdemeanor system and how that is the gateway into the criminal legal system, and figuring out ways to keep people from crossing the gate is really important.
So if we were to try to figure out, well, this is what the criminal justice is for, I think what I'm hearing from you is it's for all of those competing interests, and it depends on the different situations. Retribution might, in certain instances, be called for, and certainly I know people that would want that, number one. Rehabilitation, obviously, for the reason of wanting individuals who are going to be rejoining society to be productive members, but there's also the public safety aspect of it and recidivism, and looking at data of, you know, if you incarcerate somebody 10 years versus 5 years, what's the difference in recidivism? So there's all those different factors. I mean, it would seem to be so broad. I mean, I'm not saying we shouldn't try, but I'm hearing that these are all purposes, and to write those out of the statutes would probably be a little bit difficult.
To write them.
To say that we're only doing this for rehabilitation, for instance.
Yep. So I've done it with students to rewrite the preamble to the U.S. Constitution for contemporary times, and it's a really interesting exercise. I will confess, I haven't sat down to try to come up with one for Title 13 or for our entire criminal code. I think the exercise has a value, intrinsic value, even if you can't produce a document. Respectfully, I don't know how you can say this new law and this punishment seems appropriate without contextualizing that through broader goals. I mean, there's a somewhat anomalous thing in Title 28, Section 2A, it's the restorative justice language. It says it's the purpose or principles of the Vermont system that we will pursue restorative justice. It's in Title 28. It probably should be in Title 13 if that really is to be the philosophy of the state, but.
Makes sense. Careful.
I appreciate the piece of saying how our society is, kind of deep in the punishment, like that's what we have associated justice with. And I may be biased, but I feel like there is a shift in it, like slowly, but it is grounded in that justice is punishment. And so I feel like one of the things that comes out, because I appreciate us talking about, oh, well, it depends on this. And like, maybe we'd have to create a tailored, sentence or something for each person. In my work, what comes up against that is the fairness piece of it, of why would so-and-so only get 5 years and this, and then somebody else gets 10. So I feel like that's something we as a society have to figure out as well. Maybe that would be something in the preamble of like, we do tailor things. So I just appreciate this conversation for all of the reflection.
And there have been efforts as well, just, as far as we talked about discretion in sentencing, the part of the criminal code restructuring that we were doing is we were narrowing the box of discretion within which states' attorneys could operate, getting it closer to the average sentence, looking at, that's some of the data points that we look at. Well, what is the average sentence? So let's narrow it. It didn't get through the Senate. We passed 3 bills here, but they didn't take it up. But that was one of the efforts. That was one of the thoughts, is to narrow the broad range that we're seeing. And that's a constant, you're going to hear in the next couple of years, a constant refrain is geographic injustice that we have in the state. If there's social inequities, there's racial inequities, and there's geographic inequities. That is a thing that we try to deal with here. So
we've inherited the belief that punishment is what the response is supposed to be to criminal behavior. But that's not inherently true. I think there's a innate human desire for accountability, and there should be, but that we've conflated that with punishment. And so maybe figuring out how to parse what is accountability versus, because accountability is active. The person has to own that. Punishment, as I mentioned before, that's received. And so, you look at the maximum penalties in Title 13, these are just huge numbers that were, yanked out of somewhere. But they're not really responsive to individuals who are coming through the system.
Any other questions? And we know where to track you down if we have additional questions.
Well,
taken into restorative justice issues.
Yes, but I probably shouldn't admit this, so I won't. But as of Sunday, my spouse and I start a long cross-country trek to Snowbird in San Diego. So
Lucky.
now you're all cursing me even more than you were.
Well, we do have Zoom, so we can track.
I'd love
pretty much anywhere.
I have certainly a few other things I'd love to chat about, but not during your intro week.
All right.
Thank you all very much.
Thank you very much.
Thanks, Rob.
Hey, how are you? Good to see you.
So I'm going to ask the committee a question. We're not going to take a break necessarily right now, but what preferences are for breaks? Do we want to take like an hourly short break, or like I have scheduled here, like a 15-minute break in the middle of the afternoon? Where are people? Do we want to kind of revisit that after we've had some experience with the way I'm putting the agenda together? Any strong opinions?
I think it's maybe it should be open a little bit. I know right now with the sun and the heat, I'm feeling a little
Well, Tim has got a very exciting presentation about criminal process. So, do you want to break now before we
maybe
go?
even a report on the Giglio.
Do you need a break now, or should we just keep?
No, we can keep going, but just for, a little thought for the
Throw things
future.
at you. Does that help?
Very Catholic.
Yeah, there we go. Get chocolate. There's lots of snacks here as well.
Take me a moment to set up here.
I just want to second the short break, the desire for like
Short breaks.
every now and then, just kind of, even the 5-minute break to stand up and move your body.
Well, you can definitely at any time
Make that-
stand up and stretch in here, or even, you know, often if we have a witness.
So they're all gonna go
There's no reason you can't step over. That's absolutely fine and understood.
Gotcha.
You know, people need a comfort break or just a stretch, so.
So Tim, I have to ask you,
Oh, God.
no. Is the official name, is it Giglio, Helio?
I defer to my
Giglio? I mean,
esteemed colleague.
I've heard everything.
I have as well. I defer to my esteemed colleague.
What I will say is, all my legal career, I thought it was Giglio, and then someone said, no, it's Gilio, and I said something not nice, and then I went and listened to the Supreme Court argument, and they pronounced it Gilio.
Giglio, okay,
Well, there we go.
okay.
Yo-yo.
But no one will know what you're talking about if you say that.
Because the summer study committee, we heard 3 or 4 different ones all the time, yeah.
Right. Really? Okay, so Timothy Leaders Dumont, and state's attorney, if you can introduce yourself and say where you're from, and or are you still setting up?
Well, I just wanted to say, yes, I'm setting up with the Zoom here, but before I introduce myself, I'm just going to have this go around the room, slight interaction, so it won't be complete boredom. And I think whenever you share the screen, I'll be able to throw it up on there.
Will you just make sure your camera and your,
Yes, I will.
and you can turn your volume all the way down?
Awesome. I will do that. There was no feedback, the record show. Share screen. There we go. All righty. Everyone see that? Okay. So my name is Tim Leaders Dumont. I am the legislative assistant catch-all attorney for the Department of State's Attorneys and Sheriffs. I used to work quite a bit in this building for Beth Pierce, and so she became an expert at pronouncing my name and helping me with that process. I'm getting better at advocating for myself. But it is Timothy Leaders Dumont. Leaders like the measurement, if you pronounce your T's like that, or like the leader of the room, if you pronounce your D's like that. But it's Leaders Dumont. And I worked for Beth for many years in this building, so I know some of you from that, and I've worked with some of you over the summer on some things in the fall. And I worked for the past 2 years as a deputy prosecutor, state's attorney in Washington County. And as the professor and I were just talking about, the work is interesting. There's been different iterations of the department over the years. And before coming to the department, I handled about 1,000 cases in 2 years in Washington County. And just wanted to give you that as a brief interlude into the realm. Some people will call it the trench of deputy state's attorneys, whatever you want to call it. It's important work. I love doing the work, and I still haven't fully recovered. And I don't mean that in a bad way. I'm really still doing some cases, but love to do this policy work and talking with you all. So the goal of this presentation, you're going to laugh, there's quite a lot of words. I'm not going to read most of them. It's as a resource for you. There's links in this presentation, particularly the very last page. There's a series of links, including to the restorative statutes, and it's a resource for you. The chair asked me to do an overview of the criminal justice process, so I will do my best to do that. I'm still getting a hold of it after 3 years of law school and a few years of practice. But the document's a resource, and in follow-up, the criminal justice system, just as an introduction, is one of the most difficult places to actually assist people. And I want that to resonate with you. There's no illusions from prosecutors that it's a place where we're, it's such a difficult landscape, but we all must try when we're in the criminal justice landscape to help people. And I think those two, that dichotomy is important, that it's difficult subject matter, it's really important. And if they're there, it's a difficult place to help someone, but we must try if that's where we find ourselves. So if I'm not moving along with my slides, let me know. So, the first step is the organizational structure of the department. Excuse me, I have zoomed forward, I did. There we go. So this is the schematic I was passing along. It's page 3 in your presentation. And it looks very busy, but I think it's a pretty good one pager about the different players in the landscape of criminal justice. Obviously, the state's attorneys are right at the center there. The attorney general's over there on the left. And that's not just because we're in the Constitution. But, you know, the other thing about this landscape is it shows you just how much you have to work together with the different players. And I think about the criminal justice system like a multi-pronged stool. And if one of the legs is getting wobbly, then the other parts aren't working so well and it become quite precarious. So, you know, sometimes we work with all these different partners, sometimes we work with just one of them. And the community partners over on the right-hand side are so incredibly important. And they cover that whole gamut of community support. Sometimes we never see a case because of the good work over in the community space. But the organizational structure of the department is, you know, that the state's attorneys, first talking about state's attorneys, are elected every 4 years. They're the county prosecutors, they're constitutional officers, and we share concurrent jurisdiction with the attorney general. And in statute, it says the attorney general may do anything that a state's attorney can do. So it's sort of the inverse, but we share concurrent jurisdiction with the attorney general and most likely the criminal division of the attorney general's office. The department was created by statute to serve those 14 separate county prosecutors. And we provide all sorts of different services. There's 3 attorneys in the office, myself, the executive director, John Campbell, the appellate attorney, Evan Meenan, who I know most of you know from last year, and then Annie Noonan talks about sort of operations and labor management. And then we have IT. We have a whole bunch of things that we do, and we help to oversee the process statewide. And it's, you know, can be fascinating just to see all those different variances that we all know about. But the thing I like to say about having the department is it is that central point where if you don't know where to go within the state's attorney system, we can help sort of direct traffic and also provide support to the field, because it can be quite isolating working, you know, with a few hundred cases out in the field, and we provide support.
Just as a global perspective, can you share what the total number, you know, is of attorneys covering those 14 counties?
So I will say, stay tuned for Thursday. Judge Zone will give you a really good overview of some of the issues with the amount of cases. But we've seen, I had at any time 300 to 500 cases assigned to me. And, you know, there's numbers that are smaller, but state's attorneys and deputies, you know, carry a fairly large, certainly.
Well, that part I understand.
Oh, yeah, sorry.
We've done, you know, those visits before, close contact with our state's attorney. The question more so is globally for the state, being that you know, your department basically has jurisdiction, let's say, you know, over the whole state in the process. So we have 14 attorneys, and how many assistants?
Oh, how many so it depends on the county. Essex and Grand Isle don't have any deputies, and it just depends from there forward. And I'm happy to give you an overview of that at some point. Actually, I've got it right here. So Addison has 2 deputies, Bennington has 4 deputies, Caledonia has 3 deputies, and I'll supply this to you in writing. Chittenden has 12, Essex has none, Franklin has 6, Grand Isle has none, Lamoille has 1, Orange County has 1, Orleans has 4, Rutland has 6, Washington has 5, Wyndham has 5, Windsor has 5. The caveat, we have up to half vacancy right now, a third to half vacancies in those positions.
That's an important number.
Those are the amount that are approved. Correct.
Because if we know what the system was designed to maintain, and then we look at the pressures on those attorneys and why it's so difficult maybe to maintain adequate numbers, it might be we need to take a look at what are we doing to help support the infrastructure so that we can evenly access to justice, you know, because that's something that came up. Remember when we were doing that breakdown before, as far as the committee priorities, and it is access to justice. So actually, we're not doing a good job, in that sense, from an accountability perspective. Not to say that your 500 cases weren't adequately supported. It would have been nice if it was half of that or a quarter of that based on.
Permission to remain silent, but yeah.
Which is cool. But we're in the accountability business.
No, and I think that's a longer discussion than I think once Annie Noonan and John Campbell do our budget presentation, they can provide a lot more detail about that. And I think it combines with the topic about backlog because resources equate to time spent on cases, in this type of work.
Before you proceed.
Oh, yes.
Tim, I'm just wondering, can or do deputies work across county lines depending on caseload?
You can be deputized to assist, usually where there's a conflict of interest. So I appeared in Addison in a few instances. There can be communication, but typically, no, you work in your county unless there's a conflict. And certainly there's been instances where there's been support across the state, and the Attorney General's office has jurisdiction statewide.
So the numbers you just gave us, is there some formula like per 500 residents, there's a deputy, or is it sort of scattershot how those numbers develop, like who advocated better than?
Yeah, I would feel more comfortable probably with our operations folks answering that. But we do the best we can, and it's been a difficult hiring environment, I know, with getting attorneys to do this type of work. But it's a really good question, and I will follow up with that. Annie and Noonan and I will follow up on it. But I do want to get to the process point. And I think, the main thing I want to do at the introductory level here was show you that you might think, what's the department, right? There's the 14 states attorneys. What's the department? We're right here across the street. I'm going to be a resource for you. I'm going to try to be here as much as possible. I'm right across the street. And I see my main goal is education, foundation, so that you can make decisions. And also, if you need information, that's something I hope to do. And rather than having some strident agenda, I just want to provide as much education as possible. This you can look at later on, but we practice in the criminal division, the family division, and certainly appeals to the Supreme Court. And family division is youth, family-related issues, also extreme risk protection orders. The criminal division is adult criminal conduct, as well as some ancillary civil conduct. The criminal justice process. So in terms of that preamble, this is not in statute, but it is in the criminal rules of criminal procedure. Rule 2 says these rules are intended to provide for the just determination of every criminal proceeding. They shall be construed to secure simplicity and procedure fairness in administration and the elimination of unjustifiable expense and delay. So it is a helpful guide right at the beginning of the rules of criminal procedure, which apply across all criminal proceedings. And they also apply to law enforcement when they're making arrests, which we'll get into. The next is sort of the big picture about how the process unfolds. So first, there's the incident that leads, and I will go through these in slightly more detail. Then there's the investigation, potential arrest and citation, case intake by the state's attorney or the attorney general, the alternative justice diversion or court track restorative justice opportunities, which should remain throughout the process. If the prosecutors should be looking at those throughout the process, see if there's other opportunities down the road, adjudication, and then sentencing and post disposition, which is certainly what the professor was talking about, but it's a dynamic process. If you think about this big chart here, the whole time we're interacting with these parties and these individuals and these organizations throughout that process. And it's to serve the means of justice as opposed to gain a conviction. The incident is just where you're interacting with law enforcement. It's prior to the arrest. Rule 3 dictates when it starts to merge into that arrest landscape. And overnight, you might hear about on-call prosecutors. I did my stint here in Washington County serving in the 24/7 on-call. And it is where you learn the most as a prosecutor because it's like a final exam every night in terms of what to do with those situations and, people who pass away overnight, untimelies, unattendeds, overdose situations. Those are the things that are really where our deputies, if you think about them out in the field, that's where they're communicating with law enforcement in the middle of the night. and those initial questions about, the cheat sheet at the end, the Vermont rules of jury instructions are incredibly helpful. I refer to them constantly overnight, and they are very accessible. And I always refer to law enforcement to look at those. So the incident is that initial step into the process. Next, that may trigger an investigation. That just means that law enforcement has taken that official step to say that maybe there's criminal conduct here. That has to lead to probable cause, which we'll talk about, which could then really, result in a charge.
Can I ask a quick question?
Yeah.
How does the jury instructions help that process?
So if you think about that being the end point of the process, what someone would have to prove at trial, I always reminded law enforcement, I always thought it was a good thing for me to be thinking about, could you see this case going to trial? And when it's going to trial, these are the things we would have to prove, the elements, to get a conviction here. So thinking about those elements right at the first instance is so important, because first of all, the citizens of Vermont are supposed to be able to understand those instructions, and law enforcement. And so when they're looking at the statute saying, see section 5, I say, let's zoom to the criminal jury instructions, because that's what a judge will tell the jury the end of this process if it gets there. So I found it to be a helpful cheat sheet that many learned judges and attorneys had sort of taken the time over the years to put together. And I know it was helpful for me when I first started out as well. The Fifth Amendment really starts to kick in here, warning people it might start to emerge when they're in the middle of a custodial situation where they're not free to leave. But I will note, mere questioning at a police station is not automatically custodial. You often see this depicted on TV when they're warning folks, and it's fairly fluid in the field, but it's certainly something that law enforcement has drilled into them. And it's one of the first questions we'll ask if they have someone in custody. Did you, warn them? And the answer is always yes. And unless it's not, and then there's a problem. Next would be the arrest or citation. Rule 3 is actually a very helpful rule, and law enforcement uses it all the time. There's really 3 categories. Someone committing a felony, that could lead to a citation, could lead to arrest. Second category would be a misdemeanor committed in the presence of an officer. So that would be, your disorderly conduct downtown, DUI 1 that someone witnesses or gets involved with. And that one they can arrest or issue a citation. And there's certain schedules about when those citations go. Citation just means show up on this date, this time. In Washington County, it was every Thursday, but sometimes people will get cited out weeks in advance saying 6 weeks from now, show up for your DUI. The third is non-witness misdemeanors. That one, they've talked with witnesses, there's been a call, and those usually are a citation, but there could be instances where you arrest somebody if they have no ties to the state, if the crime is still kind of ongoing. There's a bunch of factors, which I won't read, that could lead to an arrest in those situations. There's an exception listed here for domestic assaults where you can arrest or issue a citation. Those are very difficult when they happen overnight. It's often when we get the call. And making sure that both people have a safe place to go is, as I know some folks in here work in the victim space, that's just the number one priority. And frankly, if we can avoid someone getting held overnight, we try, but sometimes in those situations, that's sometimes where you see bail being imposed, the person comes in the next day and bail might be removed the next day without paying anything, but those are the very dangerous situations that we sometimes see overnight. Next, probable cause. I've seen a prior definition from the professor on this, and I know it's a fluid concept, right? It's not something that's mathematical or scientific. It's just what a person in that situation, did someone probably commit the offense? It's not beyond a reasonable doubt. It's nothing like that. It's just that first everyday kind of interaction. That's why law enforcement and judges use it right at the entrance point to the system. And feel free to tell me I'm trying to get through the slides, but feel free to tell me to hush if you want to ask any questions.
I'm watching for hands.
Good. Or tap me if I don't see it. In practice, right, people might be lodged or held without bail, depending on the seriousness of the situation. There's a weight of the evidence hearing that may happen shortly thereafter for a hold without bail hearing. And in those situations, right, they're very serious, typically, at least the charges. And those are kind of the exceptions. Most of the stuff happens with overnight conditions of release. And as noted, there's flash cites too that happen the next day. you have to show up in court at 1 p.m. You're not being arrested right now. You have to show up in court tomorrow. The next step really in terms of our interaction is the charging decision. So the affidavit of probable cause with other information comes into the state's attorney or the criminal division of the attorney general's office. And that's that first instance where prosecutorial discretion is starting to come in, really at the foundation of our criminal justice system, not just in Vermont, but across the state, but across the country. You just because an officer thinks that someone did this crime, the prosecutor might say, that might be true, but we're going to charge this, which could be lesser or greater in terms of penalties. And sometimes if you have a really zealous defense attorney, you could be having these types of, conversations saying, I know an affidavit's coming in on this, on my client. And, at that stage, thinking about the end point, the victim, the interests of justice, as opposed to getting the maximum conviction or fine, is really foundational in terms of the exercise of discretion. And I'm emphasizing discretion here just because it's the first instance where it sort of comes into play. And only a state's attorney or a judge may dismiss a charge after it's been filed. So there's been cases where I've been involved where I charge it, and then a lot of good stuff happens for that defendant, and I dismiss it before it's ever arraigned. Or I make it clear to the court that we're not going to proceed on a prosecution. And so it's not doesn't mean the end of all just because someone's been charged. There's lots of opportunities to get away from that arraignment and certainly formal process. Yeah. Representative Dolan.
Yeah, sorry, it's on the previous slide where you had the arrest or citation, just kind of talking through the options that a law enforcement officer would have.
Yes.
And I was looking ahead, looks like it might be coming up, but I feel like there is a third option too, that it could be a referral to a community justice center restorative.
Absolutely.
Even prior to a citation.
And actually, I've sent to the chair and happy to send to all of you. I did a survey recently of our state's attorneys. There's 7 counties that have active practices of pre-charge referrals, meaning law enforcement does it, or they call the state's attorney's office and we prepare a referral. So no docket, no file. And I think that's fantastic practice. Certainly helps with the caseloads that we were talking about. And I'll have a slide on restorative justice in a moment. Oh, yes.
Maybe I'll get to it. Does that require an MOU? Or it's just pure?
Really, it's kind of the realm of sort of private, whatever works best. There are MOUs certainly between like law enforcement agencies and CJCs, community justice centers. But I've done them before where I say if that person goes to Washington County Mental Health and has anger management, 10 sessions, signs a release, sends it back to me, we're not going to charge for disorderly conduct, for example. So it's kind of, I used to really love jazz. It's the improvisational part of being a state's attorney. You can do a lot even before the charge. Yeah. So again, the next step is the initial off-ramps that Representative Dolan was just talking about. And just prior to that, I just want to touch on what happens when we charge. So there's the affidavit, prosecutor reviews. There's all these options. Decline the charges. Hold for further information. Maybe the prosecutor says, this is pretty weak probable cause. Let's get more information and see if this can be made stronger, or maybe we shouldn't be charging this at all. Bring the charges because there's adequate probable cause, and then file them with the court, which creates that docket number that you sometimes hear about. A docket could be a 3-count information. Right? That's what a docket is, a 1-count information, a DUI with a negligent operation and a resisting arrest. That's in one docket. So when you hear cases, I think really people are talking about a docket, and someone could have multiple dockets. Certainly that happens all the time.
So before you move on that, so that's the court is creating the docket number and such, right? That's part of their system.
Yeah, and the electronic filing system, administrative staff files the case, and then the court will accept it and assign it a docket number. If the judge finds, actually, and there's some situations where the judge will find probable cause as to just count 1, not count 2, still gets a docket number. There'll be a little order that says no probable cause for count 2, yes for count 1, but the docket will still proceed.
So do each count get a separate docket number, or is it just one incident that gets a docket number for however many counts there are?
Each count does not get a separate docket number. There could be multiple. When I say counts, I say there could be 4 counts in one docket.
So 4 count, give me an example.
A domestic assault with a disorderly conduct that happened and a simple assault on a police officer. That could all really happen with the same situation. They witness the domestic assault, they assault a police officer, and they then resist arrest when they're being arrested for the 2 prior crimes. That could be all filed as one docket with 3 counts.
But the same person could have multiple dockets from.
Yes. The next day, if they violate their conditions of release, there's a new docket.
Oh, okay. All right. Karen, did you have a question?
Yeah, just a quick, when a docket number is created, is that when it's now public information?
Depending on the situation, and even in those situations which may then be confidential in the future in a YO, youthful offender, it'll start out in criminal court and there might be that petition for youthful offender, which then makes it confidential, and then we don't know then it's not public anymore. And so referrals to the CJC can happen at any time, pre-charge, when you're talking with the officer at 2 a.m. in the morning, at arraignment, after arraignment. There's no prohibition on when you can use CJCs. There are certain types of cases that shouldn't go to the CJC under statute, those involving certain levels of violence. The other opportunities are, things like diversion, which is discussed in the next thing. That's usually post-charge, but pre-arraignment. So the person has a docket number. At arraignment, the judge stands up and says, you've been referred to diversion. That's fantastic. The case will be dismissed if you're successful. So they're not being arraigned. They're not saying not guilty or not guilty, but they've got that docket number sort of looming, and it can come back if they aren't completing diversion. And then it resumes, the arraignment takes place. The charging document you'll see here as a point of practice is called an information. That just means that on our oath of office, we're saying that this criminal code was violated based on this date and time with this person, and here are the penalties. And that's information to the individual, but also to the judge and the public about what's occurred so that they have warning about the potential penalties. The next slide gets into those restorative pathways. I'm not going to read from this slide. You can look at it later. But at this time in Vermont, there have never been more opportunities for prosecutors and the criminal justice system to off-ramp cases. And it was my favorite part of the job. I was the diversion CJC liaison for Washington County, and I loved it. I felt like a social worker occasionally, and I really appreciated that type of work because you're doing all that effort so that you don't have a docket later on. Or if you do get a docket, getting rid of it eventually. So the statutory sites are in here. They're also present at the end with links for you in your presentation. And take a look at them. They're really easy to read. Tamarack is for a part of the diversion programming. That's for mental health concerns and drug-related concerns. So if someone's just has a small possession case, a possession of a drug, it's a mental health. We all know those 2 areas overlap almost all the time. So maybe they need a little bit of counseling, some referrals to treatment, and then the case can be dismissed. And those sometimes are simple assaults, disorderly conducts, petty larceny, $10 at the convenience store. That's not something we should be spending our time prosecuting and bringing to trial, but maybe we can help that person now that they're in the system. Again, I'm speaking aspirationally at times and other times from practice. And at arraignment, there's a certain set of rights based on Rule 5 of the Rules of Criminal Procedure. They just have to have all the information that's being charged against them.
So Tim.
Yes.
Just a quick question. Excuse me. I continually hear snippets of aspiration. Does the department have a list of aspirations that they'd like to share with the committee as far as what we might be able to do from a policy perspective to help attain those aspirations?
What I'd love to do on that is, so that I can still get through the process here, is I would say we certainly have a discrete agenda, which is fairly nerdy. I'd say it's just 3 proposals that I've sent to the chair. One, the one that I would say just off the cuff is one about prohibition of firearms for people with the RFA. It's already in federal law. We think it should be in state law. In terms of those big picture policy aspirations, I'm certainly happy to come back and go through that with myself and the executive director. But for me, I think the department's goal is always to make the system work more effectively and to be well resourced. That's really why the department was originally created, to help with that HR resources. And I'm on 26 boards and committees working on policy year round. And that's why my position is created, not just to interact with you, but to work on these issues year round, to work on issues of Brady and the like, that doesn't matter when it happens, it's important work. But I'd say my aspirations are to educate this group, but also anyone that interacts with the system and the public about how the system is currently functioning. And then also what we can do to make it work more effectively and be resourced appropriately, because we're at times, doing our best, drinking from the water hose, getting, 100 new affidavits a week in a county office or more, while also trying to make sure that we're keeping that big picture in mind. But it is a great vantage point to see what's happening in our system and how we can improve. Certainly, yeah. And I think that I'd love to come back and talk about it further. The next one I'll just touch on for a moment. You can read about, oh, yes.
Oh, sorry. You were talking about Tamarack earlier being either drug cases or mental health cases. So what would determine a case, say a drug case going to Tamarack other than the drug court?
So treatment court, I'll talk about in just a moment, but those usually, they used to be things like simple distribution cases or possession cases that would go to treatment court. But now a higher level, and I think this is overall a very good thing, cases that previously were not being accepted by drug courts and treatment courts are now being accepted. And those are those ones that have slightly more hints of violence, burglary. We're still trying to help those folks in a way that maybe historically they weren't getting into those treatment specialty courts, but now they are. So that means it made a little bit of space for that Tamarack program to do the possession, a lot of possession cases, and ones where someone has repeated interactions and it's clear mental health, whether it's in a downtown landscape like Montpelier or Burlington, and just seeing if we can get them some counseling. So those two low-level misdemeanor worlds is where Tamarack really lives. Yep. So yeah, competency can be raised certainly at any time, and there's no, again, at the instance of issue spotting it, there's no scientific method here. Certainly an evaluator has to come in and that becomes, the diagnosis, but a judge, prosecutor, defense attorney can raise these issues. It's sometimes happens at arraignment. Sometimes it'll be identified by law enforcement. Hey, this person was, having a conversation with themselves when I was transporting them to the department. And I'm concerned about their ability to understand what I said to them. And so that stuff is really important to spot it as soon as possible, because it can greatly delay the process. And people should understand what is being charged against them. And we think it's good to spot it as soon as possible. Then DMH can get involved and have a competency evaluation. So after arraignment, any competency discussions, there will be the exchange of discovery, which should be happening immediately with arraignment. If you can get all the discovery to the defense counsel at arraignment, you should. Certainly things come up and officers find things after the fact. It happens all the time. The duty never stops. That's where Brady comes in, the obligation to disclose exculpatory information or information that might help with guilt or innocence at sentencing. All of that information has to go to the defense attorney as soon as you have it. And for, in terms of the process of discovery, for felonies, depositions usually happen, which means that there's sometimes a longer timeline, deposing all the law enforcement officers, witnesses, so those can be longer. Misdemeanors, there's no right to deposition, but you can certainly stipulate to it. And that can sometimes slow down the process too.
To back up for just a moment and explain what a Brady letter is. I think some folks may have seen that in the news and.
Not everyone read my report. I understand that. So two people here who spent time over the fall with me, but a Brady letter is when it's not a requirement, but a prosecutor can draft a letter that says, based on this information, this law enforcement officer has some credibility issues, and it can either go to its impeachment or the exculpatory information, someone's guilt or innocence. And impeachment means, Officer Sand, and I'm using as an example, was accused and then convicted of a false information charge when he was a police officer. We should all know that, right? When we're going to trial, the defense attorney should have that information so that he can cross-examine him and talk about that. And the jury should know that that might be a credibility issue. Lying on a timesheet, another pretty basic example, right at the core of their job. How many hours did you work? Oh, you said you worked 50, you worked 30. That should be disclosed to the defense attorneys so that it can be sussed out and we can really get to the truth of the matter. And if that's the only officer that you have, some prosecutors make the call that I will not accept cases from this officer. Other offices like Washington County have a much more nuanced approach. They have a step ladder system basically of, well, this, he just forgot to warn this person this one time about, they forgot to ask whether or not they had veteran status. They've never had any other issues, but I'm disclosing it in the interest of the defendant under the Constitution and due process that here's this one instance, I'm still accepting this person's cases, but I want you to know about it. Sometimes it can be the quote kiss of death for the career. Other times it can be much more nuanced and spotted down to just that one topic. And I'm happy to share that report too about whether or not there should be a law enforcement database. Now, keep in mind, not all instances of law enforcement misconduct would be, Brady or Giglio, depending on a prosecutor. But, I think that topic is important because it's the duty between myself, not with the defense attorney, but with that individual defendant. And so law enforcement officers know and that they have a duty also on their end. They're an extension of the state. So if they've got something that the prosecutor doesn't have, they got to send it to us. And the defense attorney doesn't care whether we have it or the police have it. So that duty is ongoing at all points.
And you said impeachment, that the sense of impeachment is in cross-examining somebody. It's not.
That's correct.
The other sense of impeachment.
That's correct. I know it's a loaded term.
Around and I saw Tom starting to react over from being in Franklin.
Yeah, it's the truthfulness of the individual and being able to suss that out. Yep. So the.
Quick question.
Oh, yes, sorry.
With discovery, I guess I didn't realize it. It's only that the prosecution side has to give information to the defendant side. Defendant side doesn't have to give, if they find something or something, they're not.
It sort of depends. If there's certain, I had a trial where the defendant brought in the alleged knife that they had and they brought it with them to trial that morning. They had not disclosed it until that morning because they could not find it. I thought they could find it, but it's fine. And they showed it to show how small the knife was, right? And they brought it into the courtroom that morning. I would have loved that information a month prior, 3 months prior. But if I put in a discovery request, yes, we usually put it right at the front end under the rules that they should be disclosing information. And they have to disclose certain defenses in advance. And usually some of this can get litigated through the course of discovery. But yeah, it could be everything from an email between a law enforcement officer and, the defense attorney. I was talking with this law enforcement officer. He disclosed this. You may want to know this, state of Vermont. You may want to know this, victim, that this officer said this after writing his affidavit. Could ruin the case. It could shed light on maybe why we shouldn't proceed with it. That's usually the way that I've received the discovery in the ongoing fashion. But the duty that the prosecution has is just when you have it, you send it over.
But the defendants, they don't have to turn over anything that would be a Fifth Amendment violation, right? I mean,
certainly they wouldn't have to turn over anything that is just between them and their attorney, and certain information that isn't really about evidence, but more about strategy. And the two can get kind of murky when you're in the process of preparing for trial. But the disclosure of certain witnesses, if they're going to have a witness.
More disclosures, and I mean, so the witness, the defendant doesn't have to necessarily turn over that knife unless they're going to use it in trial, or am I wrong about that?
I mean, if they have the knife that's being charged, the knife is the alleged weapon, law enforcement couldn't recover it, they should be dropping that off. That's a part of our discovery, right? Our request to them. And I mean, Professor, I don't know if you have any comments on it as well. I know it's not, I mean, the duty that we have as prosecutors feels very black and white to me.
Yeah, that's a much more straightforward duty. I was just wondering where that ends with the defendants or what duties they really have.
I'll also say that the consequence of non-disclosure is very different. It might be dismissal if it's the prosecutor who doesn't disclose. It might be that piece of evidence doesn't come in if the defense failed to disclose.
Right. I objected to the introduction of that knife on the morning of, but I wasn't successful.
All right, thank you.
Yeah, and so then this leads to motion hearings about all these things we're just talking about. Motions in limine, which are about evidence. That can happen at trial or anytime prior. Motions to dismiss the case. You don't have enough evidence, state. Let's talk about this beforehand. And those might require witnesses to show up and even victims to show up. And sometimes the defendant may even present a little bit of testimony there in a limited fashion. Conditions of release. These conditions are way too restrictive. My case has been pending for a year. So then we can review those. So there's certain duties to review those in short periods of time. And then motions to suppress evidence because they're were seized illegally in opposition to the Fifth Amendment, to any of the constitutional rights. Those sometimes involve, people think about them in car stops all the time. Did they had consent to go into the car? What did they have consent to do? It's always best to get a search warrant for everything, but that's where you run into problems with those. And even if you have a search warrant, there can be questions about those too. The next is those status conferences that happen in between. They're that check-in with the judge. Hopefully they create opportunities for discussions of resolution, plea agreements, dismissal, right? This person has done all these things and making that kind of argument. Or potentially it's also an opportunity for restorative justice to kick in again. This case, upon further review, should go to the Community Justice Center here in Montpelier, because this person has actually really done a great job on these matters, but they should engage with the victims about what that harm did to the victim, to the community, maybe have a reparative board in the local community. And so those things never stop. The opportunities for restorative justice never stop. The victims have to be notified throughout. There's victims' rights codified in statute about what's happening with these hearings in adult criminal court. And they have opportunities to weigh in at sentencing, as Professor Sand was talking about. But if there is a plea agreement, the judge can either agree to it or not agree to it. If he doesn't or she doesn't, they don't agree to it, then it resumes for prosecution. The jury draw would be the next step if you haven't settled your case. That's the cross-section of the community, a jury of your peers. Usually a lot of people in a room and none of them want to be there, and you feel like you're a comedian and no one's laughing. Red Sox jokes and Yankees jokes sometimes sit well depending on where you are. What you're trying to get is a fair and impartial jury, a group of people. And I like to think there's no bad questions at jury draw. You don't want to be saying the right answers. You want them to say what they actually think. So if someone says, I think all cops are lying all the time with no exceptions, then that person would have a hard time listening to a police officer testify. If another person said all attorneys, tend not to tell the truth, right? That's a problem for both myself and the defense attorney. So you want that person to maybe not be on your jury. I had one recently where a certain higher member of a religious institution was on a jury, and a certain former member of their group that went to see him every Sunday was also there. And the priest was allowed to stay, but the parishioner was not. Because he said, I can't sit with my priest. If he tells me something in the jury box, I'm going to have a hard time maybe not listening to him. So you talk about the themes of the case in these jury draws. Presumptions of innocence beyond a reasonable doubt for the state to prove, direct versus circumstantial evidence. And by the way, there's no preference there. Circumstantial evidence, direct evidence, it's all evidence. One is not favored over the other. Victims are not usually present at jury selection. With WebEx, maybe they could listen in, but the idea is not to have the victim sit for a long time with the defendant in that room where people are doing it. But you say, do you know any of these witnesses? Do you know the victim? Do you know the defendant? Do you know me? Jurors can't have a direct connection with people in the case.
So can I ask a question about the plea bargaining? I see in the previous page, those discussions can happen all the time, but how much, when are those usually bargained out? When did the settlement usually occur? Is it critical to have a date set for either the jury draw or the actual trial? Or is the trial set and the jury draw kind of backs up from that?
What usually, I would say that the plea agreement, so the offers to settle should happen at arraignment for a lot of cases. Sometimes there's no offer that really makes sense because you still need more information, like with major felonies. But with misdemeanor cases, for example, for a DUI, I may offer something like, for a first-time DUI, maybe a fine only, with an opportunity to, if they take safe driver and they write a letter of apology to the mailbox that they smashed. That's an opportunity for making that offer initially, but then the defense attorney, you can go back and forth for a while. But if you don't have that initial offer, it's hard to kind of start off. So I will say that when jury trial dates are set, there is a lot of activity in the plea agreement realm, as you suspect. And that's often it happens on jury draw, or the final pretrial conference is really where most plea agreements would happen in the major cases. The final status conference before jury draw, where the judge says, today's the last day. Even though they might accept something after that point, they might say, I'm not accepting plea agreements after today. We got juries coming in. I've seen judges say that, and then they also accept them because it's a plea agreement that resolves the case. But it's pressure, certainly, the pretrial conference. Thanks. So the trial process, which usually tracks with aspects of the cinematic experience that you've all seen, is the opening statements by the state, then the defense. The state must prove the case beyond a reasonable doubt, which is the highest standard in the law. The state will present its case and then put on evidence, direct examination of state's witnesses, introduce physical evidence if there is physical evidence, photographs, audio, video. The defense will make its objections, cross-examine the state's witnesses, and so forth. At that point, usually a motion to acquit happens after the state rests, and then there's a small sidebar arguing that the state has met its initial burden, which is the same as a motion to dismiss before trial, but there's a little mini litigation that happens outside the hearing of the jury typically. Then the defense goes if the motion to acquit is not upheld and is not approved by the judge. And they may put on witnesses, they may not. They do not need to, and they could just proceed by cross-examination of the state's case. The state has the opportunity to cross-examine and potentially rebut. If they put on evidence that isn't a part of the state's expected pathway, the state could rebut with a rebuttal witness, bring back the police officer, to talk about what happened in response to the defense. And as noted, objections to evidentiary disputes happen throughout the trial. Those happen at the bench. The jury doesn't hear those in theory. Hopefully they don't. Then there's closing arguments by the state and then the defense. The state may then respond with a rebuttal, and the jury is then read those jury instructions, which are linked for you in the back of the presentation, which I think are so helpful. That's the law that they have to apply when they're considering the circumstances. And then they deliberate. They have to be must be unanimous. The jury verdict would be guilty, or they could disagree. And a finding of not guilty or hung jury or mistrial is not the same as innocent in terms of it's just that jury said the state didn't meet its burden in terms of a not guilty, or they couldn't agree in a mistrial. In the case of a mistrial, they can certainly refile the case. And there was a good documentary recently called Trial 7, I think, about the now U.S. Attorney for the District of Massachusetts. There were 7 trials in Boston for the same person, and they were all mistrials, so that can happen. Without double jeopardy kicking in, which is you can't be prosecuted for the same crime twice. If guilty, then you proceed to sentencing. For misdemeanors, that could happen that day. For felonies, there'll be a pre-sentence investigation. I know Professor Sand talked about sentencing and the goals, so I won't cover that territory too much. And then different theories behind it, some of which are in case law and statute. And it's always, I'd say sentencing arguments are kind of the most intense, and they should be part of the process. To me, much more the humanity aspect of what you're doing at sentencing kicks in. If you're a prosecutor, and certainly if you're a defense attorney, even if you lost the case, you're still arguing. The case is not over, just because the case might have been decided against you. The judge will order PSIs for felonies. That's a little mini investigation into, and they're not so little in a lot of cases, that person's history. And, you know, we talked about it with some of the hypothetical that you were given. What happened in that person's life? What was happening right up to that moment? Who are the supports in their life? All those different things are incredibly important and should be.
PSI?
It's a pre-sentence investigation, and the Department of Corrections puts those together for the judge to consider. And they don't make a necessarily recommendation about how much the judge should weigh different things, but it's all supposed to help the judge in considering what sentence to impose. And it's changed over the years, that the form and the substance that goes into these PSIs, that DOC can testify more about some of that. But they used to be maybe more elaborate. Now they're a little bit more structured and formed. Yeah, yes.
Why does corrections do PSI? Smile's telling me something.
Well, I think that the legislature at one point decided that if they're about to be remanded, you know, into their custody, there should be some aspect of the correctional oversight that kind of thinks about what happens before they even get to us. But frankly, I'm not sure that legislative history onto why it's DOC as opposed to not some other entity or agency. Yeah. So something I wanted to touch on is specialty courts, treatment courts. They're in Chittenden for adult drug treatment and adult mental health treatment. Rutland for adult drug treatment. Washington County has the adult drug treatment court here, and then Windsor has a DUI treatment court. And these are specialty courts that offer wraparound services for people, and usually what's called a door A and a door B for a sentence. If you do really well in this program and you graduate from this program, you're going to probably receive a better outcome as to a sentence, sometimes even a deferred sentence, which eventually means that the sentence goes away, or a dismissal in some cases, but often it's just a better sentence than you would have, you know, had. And the state is being upfront. Here's the sentence. If you complete it, here's the sentence. If you don't, I believe in some instances there might be open sentencing that still happens. But there's the door A, door B concept also happens in federal court in Vermont, in Burlington, and Rutland. And it's when I was working for Judge Crawford as a clerk that I saw that process, and then I saw it here in Washington County, and it's such an important part of our system. And the reason that's in these locations is a decision that the judiciary obviously makes, and sometimes someone can be referred to another county, even though if they have some contact, however slight, with that county to get an opportunity in that treatment court. Yes.
Karen,
yes.
Or Ella, then Karen.
Yeah. This is new to me. Can you just describe a little bit about how long the treatment courts have been around and the history and how that's evolved real quickly?
So there's a whole presentation that I could do on treatment courts, but Professor Sand, do you know when they first started treatment courts in Vermont in the state system?
No.
Yeah.
Spread out over time, all federally funded.
Yeah, and so there's certain federal parameters about receiving the funding, which creates some restrictions on what they can do. But there's a whole team of people, like the court has a staff person. There's mental health and treatment providers. Usually there's a defense attorney that's sort of assigned to kind of cover that docket, and a prosecutor assigned. And usually those prosecutors and defense attorneys are doing drug or alcohol related, in Windsor's case, related cases. So they kind of have a good understanding about folks, and they may know a lot of those individuals. It's an informal process in some ways. You go into the court and you have this great discussion with the judge. How was your last couple of weeks? You made all your treatment appointments. How are you feeling? How are you doing? And sometimes there's things like they get little incentives, which sounds kind of trivial, but it feels really good to have a judge say you did a good job. So I have been very emotional. I had a graduation in federal treatment court myself after seeing someone go through a lot and come through the other end and then become a coach, a treatment coach themselves. So it is wonderful program that happens in, the places that have a clear need for them, and just in terms of the treatment-related activity that's happening in those locations. But it doesn't mean that it doesn't happen in other places too.
Judge Valenti said those incentives have worked incredibly well.
Yeah.
So when is the treatment court? What day of the week is it?
They do it on Mondays.
Okay, I thought it was Mondays.
Yeah.
So if anybody's really interested, I've gone to one of the graduations before. It is
Really worth it.
Yeah, it's really-
Yeah, I should take this opportunity to say, if you ever want to see an arraignment or treatment cart, I'll go over with you to the courthouse in Barry or another courthouse, and I'd love to sit and talk with you about any of that, so.
Burlington's Thursday afternoon.
It's Burlington is, yeah. So-
And is there fairly robust data kept on?
Yes, the treatment, there's actually a reporting that has just, I think it's coming out soon or is coming out about the success and the number of people. And CRG, Crime Research Group, has some data, and then there's another provider that has an agreement. And I can actually look into providing some information to you on that, because I do think it's been helpful. It's a great success story in terms of keeping things out of the criminal. I mean, they're still in the criminal track, but they're kind of off to the side. And they can certainly be terminated from treatment court. The number one thing is honesty and accountability in terms of goals.
So Karen.
Yes, so just how folks are referred to it, is it up to the individual state's attorney to make that referral? And I see that there's only some counties are listed. You said some people might be able to. I'm looking at it from the geographical equity lens.
Yep.
And if you can speak to that at all. Is it equal right now, or is it depending on different states' attorneys?
So the first question, state's attorneys may make a referral, but also I know it sounds kind of wishy-washy, but a defense attorney might come in with a robust argument about why, and then the state's attorney kind of has an agreement to refer. Then there's a screening by the staff about whether or not this person would be a good fit. And that is the most important thing, the screening opportunity, because even if, the thing that I always like to think about is even an unsuccessful treatment court process might save someone's life. And if you think about treatment court as being harm reduction, which is the whole point, someone says, how successful are treatment court? I'd say, if people are alive, then treatment court is doing its job. And the recidivism is an important part too, because victims, you think about the victim input on treatment court, they want to know, is that person showing up at treatment court every Monday? Are they doing what they're supposed to do? Because my victim case is pending because that person's in treatment court. So they want to know what's happening too, in terms of that accountability side. And, I've seen very eloquent victim impact statements about how great it was to see someone turn their life around in treatment court. But in terms of the geographic aspect, I'd say that, without getting into too much detail, there might be lots of reasons. These counties are ones that a lot of Vermonters come through. You don't have to be a Chittenden County resident to go to Chittenden County Treatment Court. A lot of Addison County residents might go to Rutland or Chittenden because they're right in between. Orange County residents might interact a lot with Washington County. So it does cover a really good portion of the state. A lot of the Northeast Kingdom folks that might interact with Washington County because that's where they work. It's not certainly this justification about volume. And so you don't want a large volume in the place where you are, but also that access is an important thing. So I think it's a bit of a balancing point, and I can't quite say my analysis about.
But all of those are a tool that are available to all states' attorneys.
They could certainly make a case to send a case to transfer it to a treatment court. Yeah, that's correct. Or the attorney general's. The attorney general can obviously make referrals too.
So can you come back? Will you be here at 3:00? Because I would like to stay there, because I think even though you only have one more case, there may be some other.
Yeah, no, that's totally fine.
Well, so break until 3.
Sounds good.